Hello, everyone. First of all, I would like to thank the organizer for inviting me to this event, and I also want to congratulate them for organizing such an exciting gathering of young scholars in human rights. I think it's impressive to see how many young researchers are working on human rights issues today in Belgium, and also the variety of subjects and sub-disciplines they are touching upon. I think it's interesting to note that it probably would not have been possible to find so many participants for a similar event 20 years ago, which in itself tells us something about the remarkable development of human rights law in the last decades. For long, human rights had a marginal place in law faculty. There were, at best, a small chapter in public law or international law courses. They were also considered by many as not being really law. Now, on the contrary, it is an established subject with a growing number of human rights study programs and human rights research centers. And this growing recognition in the academic sphere certainly reflects the importance taken by human rights in legal practice. As the presentation to this conference highlights, human rights now seem firmly enshrined in European legal orders throughout national constitution, international treaties, EU treaties also. They have been granted and recognized a foundational position in present-day law. They are officially recognized as the ultimate criteria to evaluate the soundness of the law. And in social practices, they also play a crucial role in political and social debates and struggle. And this is certainly an impressive evolution. And yet, as the title of my presentation suggests, my purpose in this presentation is to moderate somewhat this enthusiasm about what we can call the legalization of human rights. And I want to bring attention to two sorts of concern. I first want to talk about the flip side of legalization. And secondly, I also want to say a few words about the limits of legalization, the limits of the legal protection of human rights. And both sets of remarks will lead me to a common conclusion that legal protection of rights, even today, remain more fragile than it seems. So first, the flip side of legalization. So the legal recognition of rights and the establishment of a legal system of protection through legislation, constitution, international treaties, through various institutions, both national and international, through legal remedies, no doubt has done a lot to advance and protect the interests and values that are represented by human rights. However, legalization also has its reverse side, and it has some ambivalent consequence which have appeared with experience. A first consequence is the complexification or technicization of human rights. While originally a political and philosophical ideal, they have been transformed into a technical legal concept which requires special training and knowledge to be mastered. Human rights have been integrated into the complex whole formed by legal code, prescription, institution with its specific language, rules of reasoning and interpretation. They have become a domain of expert, which is not of an easy access for layperson. And this is in tension with the ideal underlying human rights, to have a protection that is readily available to any individual, and especially the most vulnerable. In practice, most people would need the help of a lawyer to be able to really understand what legal rights mean, what they are entitled to, and how to use the legal remedies that when they need it in case of violation. This gives lawyers a special role and also a special power. And it also entails potential inequalities between those who can easily benefit from the services of a lawyer and those who can't. For instance, in the NGO world, you can see clearly different attitude towards using rights or not to promote their cause, depending on whether such NGOs have a lawyer in-house. And in the field that I've been working a lot on, the field of non-discrimination, I realized that many small NGOs working on issues for which anti-discrimination law could be very useful, could be very relevant, do not use this law because they just don't know it and they don't know how to use them. So that's the first consequence. Another disturbing consequence of legalization of human rights is that once recognized by law, rights become legal tools. They become legal arguments which can be used for any sort of purpose, including purposes which can be very remote from the ideals of universal justice, equality, emancipation, which have inspired the philosophical concepts of rights. For instance, we can find various examples of cooperation invoking the right to privacy, to refuse disclosing documents, information required by the authority, for example, in the context of investigation on their trade practices, or in the fiscal context in order to determine their fiscal situation. Another interesting example is the case of credit rating agencies like Standard & Poor's, using the right to free speech to oppose legal action that have been lodged against them after the subprime crisis. To those who accuse them of having incited people to take unreasonable risk by diffusing flawed information, which was partly explained by a problem of conflicts of interest these agencies were in, they answered that their ratings were merely opinions protected by freedom of speech, and that therefore they could not be held liable of the consequences. And I've seen that there will be a presentation on this issue at this conference by Jan de Bruin, which I'm looking forward to hearing. And we could find many other examples of this kind. A last example is when rights are used instrumentally to oppose other right-based claims. For instance, in the field of non-discrimination, there had been examples of employers or landlords invoking the right to property to contest non-discrimination rules, arguing that they should be free based on their right to property to hire or rent their house to whom they want. So, as legal scholars, I think we need to reflect on these phenomena, and we need to think about also our special position as lawyers, as human rights lawyers. We should ask how, despite their technicality, human rights concepts and remedies can remain accessible to those who most need it. And also, we should also reflect on how human rights can avoid becoming a merely technical, formal, abstract concept who can be rigidified or even distorted by the law. And in this perspective, it's important to reflect on ways to keep open the channels of communication between the legal sphere, legal actors, legal institutions on the one hand, and on the other hand, social movements, activists who engage in the defense of rights in the real world. These movements, these committed citizens, by questioning, by unsettling established understanding of legal rights, by bringing new claims, new perspectives, new ideas, can contribute to enrich and reinvent the meaning of legal rights. And I think this is something that we should keep in mind. I now turn to my second set of observations on the limits of legalization. And here, what I have in mind is that while in appearance the recognition of right as foundational norm is overwhelmingly accepted in Europe, while it appears at first sight as a success, in practice this achievement is much less solid than it seems. Despite regularly praising human rights as a core European values, in practice state authorities remain ambiguous towards this concept. This is probably not very surprising, as human rights are basically a constraint placed on the freedom of action of decision makers. And therefore, even those who sincerely believe in democracy and human rights are always tempted to resist this sort of constraint. So in practice, human rights, despite all this achievement, continue to meet with resistance and challenge, and these resistance are today more alive than ever. We are, of course, familiar with situations where state authorities adopt measures which restrict certain rights in the name of various public interests. Today, there are a lot of debate about measures adopted in the name of the fight against terrorism, among other objectives. But in such context, at least it is admitted that the measures at stake raise a human rights issue. And there can be a debate on whether these restrictions are legitimate and proportionate according to human rights standards. But we also observe, I think, more insidious forms of challenge of human rights, which are in a way more profound because they possibly affect the very status of human rights as primary norms, as ultimate criteria to evaluate state action. And I want to talk about two attitudes. A first attitude consists in merely ignoring human rights when acting in certain domain, as if they were simply irrelevant. And the example I have in mind here is the Greek crisis and the policy of European institutions and the IMF regarding the conditionality that was imposed on Greeks for receipt of financial assistance. We know that Greece was, in this context, required to implement very drastic austerity measures which included dramatic cuts in social spending in fundamental areas such as, in particular, pensions, healthcare, and basic services. It also had to carry out very serious labor market reforms, which included reducing the minimum wage, facilitating dismissals, limiting collective bargaining. And it was predictable that this sort of measure could negatively impact on the enjoyment of social and economic rights. And yet, when these economic adjustment programs were elaborated and negotiated, neither EU institutions nor Greek authority had regard to these rights. There was no social impact assessment conducted before or after the implementation of this measure. There was no effort made to try to find a way to reconcile budgetary and financial objectives with the safeguard of the enjoyment of socio-economic rights, and especially of the most vulnerable. Human rights were simply ignored in this context, as if they were irrelevant where economic imperatives were at stake. Now, complaints have been brought to the European Committee of Social Rights by some Greek organizations, and the committee did conclude that there were violations of the European Social Charter that resulted from some of these measures. It found a violation of workers' rights and the right to social security. Experts have also argued that the reform implemented in the sector of health had resulted in violation of the right to health, given that large segments of the population have become unable to access basic health care. And yet, this does not seem to have led to any change of attitude from EU institutions or Eurozone member states in the continuing process of negotiation with Greece. And this despite Article 2 of the Treaty on the European Union stating that the Union is founded on the values of respect for human dignity and respect for human rights, despite the EU Charter of Fundamental Rights providing for various social rights which could have been relevant in this context. Of course, I don't want to enter into the debate, the legal debate here. EU member states and EU institutions involved in this process were acting outside EU law, and the issue of legal responsibility is very complex, but still the total disinterest for human rights imperative in these circumstances, when contrasted with the foundational role that is acknowledged to rights in national constitutions and EU treaty, is disturbing. A second preoccupying attitude we can see developing among European states consists in contesting not human rights themselves directly, but the authority of institutions that have been created to protect human rights. And what we can see today is, I'm thinking to the situation of the European Court of Human Rights, which today is a target of very serious attacks by some Council of Europe member states, including some old democracies who were among the founders of the convention system, like the UK and the Netherlands. And in the UK, more specifically, the Conservative Party, who just won the election, has a very concrete project of reforming the human rights law in this country, with a view to seriously limit the reach of European Court judgment in the UK. And it explained this project by claiming that the court is abusing its power and is unduly expanding conventions' rights. So they propose, the basic idea in the project is to simply limit the court to being an advisory body, so that UK courts and parliament would not be bound anymore by its judgment. And they also want to limit the applicability of human rights law to the most serious case, those that involve, I'm quoting, criminal law and the liberty of an individual, the right to property, and similar serious matters. And they also say that if these reforms are not accepted by the Council of Europe, the UK will simply withdraw from the convention. So, of course, European courts' judgment can be criticized, and they are not always convincing or well argued. But what we discern here is a rejection of the basic role of the court and of the logic of human rights themselves. And this distrust of the European Court is revealing of a distrust of human rights themselves and of an unwillingness to accept subjecting its laws to serious scrutiny by an external actor. And I think it's important to stress the necessity and the reason why in the human rights field we find it necessary to have a control not only by internal actor but also by an external institution like the European Court. It is because an external actor is more likely to be really independent from internal forces, but also because it can cast a fresh look on contested internal national legislation or practices, and it is less likely to be influenced by the dominant, well-established perception of the problem. So it is part of the logic of human rights to accept such external control and to accept engaging in a dialogue with international supervisory institutions rather than seeing them as competitors, as threatening the power of national institutions. And lastly, here at this point, we can maybe draw a parallel between this attitude and another recent event in the human rights field, which is the opinion delivered by the European Court of Justice in last December on the accession of the EU to the European Convention on Human Rights. To the surprise of many experts, in this opinion, the court held that the draft agreement on EU accession to the convention was incompatible with EU treaties, arguing that it was likely to have negative effects on the autonomy of the European Union law and its specific characteristic. There is, of course, ample legal justification, ample legal analysis supporting this conclusion. And yet, when reading the opinion, it is hard to escape the impression that the court is primarily concerned with defending its own power vis-à-vis the European Court of Human Rights. And in this regard, I'll just mention one argument, which I think is particularly disturbing. It's the argument concerning the common foreign and security policy. The court argues that since the Lisbon Treaty excludes its own jurisdiction on CFSP matters, to the exception of restrictive measures, since the European Court is thus incompetent in this field, it would therefore be incompatible with EU law to confer jurisdiction to another court, namely the European Court of Human Rights. So, like the British Conservative, the European Court of Justice seems basically reluctant to accept a human rights-based external control. It seems to see the European Court of Human Rights primarily as a rival rather than as a partner. It seems to give more importance to the preservation of its own power than to the achievement of a more effective legal protection of individuals' rights across Europe. And this is detrimental to the European Court of Human Rights legitimacy and at the end of the day to human rights themselves. So in conclusion, we can say that the construction of an effective legal protection of human rights is a never-ending enterprise. Despite all the important institutional achievement, despite the increasing conceptual sophistication of human rights law, it remains a fragile enterprise. It remains fragile because law as a means of protection has its downsides, and fragile because it recurrently faces defiance, resistance, and challenges. And I think we should keep that in mind when doing research in the field of human rights. I thank you for your attention.